Contracts are an integral part of our daily lives, from purchasing a cup of coffee to buying a house. A contract is a legally binding agreement between two or more parties that outlines each party's rights and obligations. Understanding contract law is essential for anyone who wants to enter into any agreement, whether personal or business-related. Contract law in India is governed by the Indian Contract Act, 1872. This act defines the essential elements of a contract, such as an offer, acceptance, consideration, capacity, and legality. It also sets out the rules for contract interpretation and enforcement. Contract law is crucial for businesses, as it governs their dealings with customers, suppliers, and employees. In addition, individuals can benefit from a basic understanding of contract law when entering into agreements such as lease agreements, employment contracts, and service contracts. Today, we will cover Indian contract law basics. We will start with an explanation of the essential elements of a contract and the formation of a contract. We will then cover various types of contracts in India and the legal aspects of Indian contracts, such as contractual obligations, interpretation, and enforcement. Finally, we will discuss the use of electronic contracts in India and contract drafting in India. Whether you are a law student, a lawyer, a judge, or simply someone interested in contract law, this will provide you with everything you need to know about Indian contract law. To form a valid contract under Indian contract law, certain essential elements must be present. These elements are as follows: offer and acceptance. An offer is a proposal made by one party to another with the intention of creating a legal relationship. Acceptance is the indisputable agreement to the offer terms. Both the offer and acceptance must be clear, certain, and communicated to the other party. Consideration. Consideration is the price paid by one party to another for the promise made under the contract. It can be in the form of money, goods, or services. Consideration must be something of value and must be given in exchange for the promise made. Capacity to contract. The parties entering into a contract must have the legal capacity to do so. This means that they must be of sound mind and have attained the age of majority. Free consent. Free consent is the voluntary agreement of both parties to enter into the contract. Consent is said to be free when it is not obtained by coercion, undue influence, fraud, misrepresentation, or mistake. Lawful object. The object of the contract must be lawful. Contracts with unlawful objects, such as contracts to commit a crime or engage in immoral activities, are void. These elements are the building blocks of a valid contract under Indian contract law. It is essential to understand these elements to ensure that your contract is legally binding and enforceable. Contract title. This contract is made and entered into on date by and between Party A with a mailing address of address Party A and Party B with a mailing address of address Party B. Party A and Party B may be referred to individually as party and collectively as the parties. Scope of work. Party A will provide the following services to Party B. The services. Description of services. Payment. Party B will pay Party A the following compensation for the services. Payment details. Payment will be made under payment terms. Term and termination. This contract will begin on start date and end on end date unless terminated earlier in accordance with this section. Either party may terminate this contract at any time upon termination notice period days written notice to the other party. Confidentiality. Party A agrees to maintain the confidentiality of all information it receives from Party B in connection with the services. Party A will not disclose such information to any third party without Party B's prior written consent. Intellectual property. Party A agrees that any intellectual property it creates in connection with the services will be the sole property of Party B. Warranties and representations. Party A represents and warrants that it has the necessary qualifications, experience, and expertise to provide the services. Indemnification. Party A agrees to indemnify and hold harmless Party B from any and all claims, damages, or expenses arising from any breach of this contract by Party A. Governing law. This contract will be governed by and construed in accordance with the laws of governing law jurisdiction. The entire agreement. This contract constitutes the entire agreement between the parties and supersedes all prior agreements and understandings, whether written or oral, relating to the subject matter of this contract. Signatures, Party A. Party B contracts can be classified into various types based on their formation, performance, and enforceability. Some common contract types are as follows: express and implied contracts. An express contract is a contract in which the terms are explicitly stated, either in writing or verbally. For example, a homeowner signs a written contract with a contractor to build a deck in their backyard, specifying all the materials, dimensions, and the agreed-upon price. An implied contract, on the other hand, is a contract in which the terms are not explicitly stated, but inferred from the conduct of the parties. For example, you walk into a coffee shop, order a coffee, and hand the barista money in exchange for the coffee. Although there's no written or verbal agreement, there's an implied contract that you will receive the coffee in exchange for your payment. Unilateral and bilateral contracts. A unilateral contract is a contract in which only one party makes a promise, and the other party accepts the promise by performing a specific act. For example, a company offers a reward of 500 rupees to anyone who finds and returns their lost dog. If someone finds the dog and returns it, the company is obligated to pay the reward. The bilateral contract, on the other hand, is a contract in which both parties make promises to each other. For example, you agree to sell your bicycle to a friend for 100 rupees, and your friend agrees to pay you the 100 rupees. Both parties have made promises to each other, forming a bilateral contract. Executed and executory contracts. An executed contract is a contract in which both parties fulfill their obligations under the contract. For example, you hire a painter to paint your living room. The painter completes the job and you pay them the agreed-upon amount. The contract is executed because both parties have fulfilled their obligations. An executory contract, on the other hand, is a contract in which one or both parties have yet to fulfill their obligations. For example, you hire a moving company to help you relocate to a new house. The company has packed your belongings, but hasn't completed the move yet. The contract is executory because the moving company still has obligations to fulfill. Voidable and illegal contracts. A void contract is a contract that has no legal effect from the beginning. For example, two minors, individuals under the legal age of consent, enter into a contract to buy a car. Since minors lack legal capacity to contract, the agreement is void from the beginning. A voidable contract is a contract that is valid but can be voided by one or both parties due to some defect or lack of legal capacity. For example, an individual signs a contract to purchase a car but later discovers that the car has a significant defect that the seller didn't disclose. The buyer has the option to void the contract due to the seller's fraudulent misrepresentation. Illegal contracts are contracts against the law or public policy and therefore unenforceable. For example, two individuals enter into a contract to engage in illegal drug trafficking. Since the contract involves illegal activities, it is unenforceable and illegal. Understanding the different types of contracts is essential to determining the nature and enforceability of the contract. It is vital to ensure that the contract is properly classified to determine each party's rights and obligations. The formation of a contract is the process by which a contract is created and legally binding. Under Indian contract law, a contract is formed when an offer is made, and that offer is accepted by the other party. How contracts are formed in India, contracts can be formed orally or in writing. However, certain types of contracts, such as contracts for immovable property sales, must be in writing and registered. The Indian Contract Act, 1872, governs contract formation and enforcement in India. Differences between oral and written contracts. The essential difference between oral and written contracts is the manner in which the terms of the contract are documented. Written contracts are usually more formal and comprehensive and provide greater certainty and clarity than oral contracts. Oral contracts, on the other hand, can be more flexible and allow for greater negotiation and discussion. The role of electronic contracts in India in recent years. Electronic contracts have gained popularity in India. Electronic contracts are contracts formed electronically, such as through email or other forms of electronic communication. The Information Technology Act, 2000, governs electronic contracts formation and enforceability in India. Electronic contracts have several advantages, such as convenience, speed, and cost-effectiveness. However, they also pose unique challenges, such as ensuring the authenticity and integrity of the contract and its signatories. Understanding the formation of contracts is essential to ensuring that your contract is legally binding and enforceable. It is important to consider the specific circumstances of your contract and determine whether it should be in writing or formed orally or electronically. Contract interpretation and enforcement interpretation of a contract refers to the process of understanding and determining the meaning of the contract terms. Enforcement of a contract refers to the legal process of ensuring that the parties fulfill their obligations under the contract. In India, contracts are primarily governed by the Indian Contract Act, 1872. This act lays down the general principles governing contracts, such as offer and acceptance, consideration, capacity to contract, free consent, the legality of an object, and other essential elements. When a dispute arises between parties to a contract, they can either approach the courts or opt for alternative dispute resolution mechanisms, such as arbitration or mediation. India's courts play a vital role in interpreting and enforcing contracts. The courts are responsible for enforcing the terms and conditions of the contract. They may also interpret the contract to resolve any disputes that arise between the parties. In India, there are several types of courts that handle contract disputes. The district courts have jurisdiction over contract disputes involving amounts up to a certain threshold, while the high courts have jurisdiction over disputes involving higher amounts. The Supreme Court is the highest court of appeal in India and has jurisdiction over contract disputes that involve constitutional issues or questions of law. In addition to the courts, alternative dispute resolution mechanisms, such as arbitration and mediation, are gaining popularity in India. Arbitration is a process where an independent third party is appointed to resolve the dispute between the parties, and their decision is binding on the parties. Mediation is a process where a neutral third party assists the parties in resolving the dispute by facilitating communication and negotiation between them. Note: in a contract, a third-party beneficiary is someone who is not a party to the contract, but has the right to enforce certain terms of the contract. The third-party beneficiary may be identified by name in the contract or a member of a class of individuals, e.g., employees, customers, or creditors, who are intended to benefit from the contract. Arbitration is governed by the Arbitration and Conciliation Act of 1996, and mediation is governed by the Civil Procedure Code of 1908. Both of these mechanisms are considered faster and less expensive than litigation in the courts. How courts interpret contracts in India. In India, the courts interpret contracts based on the plain meaning of the language used in the contract. If the contract language is ambiguous or unclear, the courts may look at the surrounding circumstances and the intentions of the parties to interpret the contract. Remedies for contract breach: if one party fails to fulfill their obligations under the contract, it constitutes a breach of contract. The Indian Contract Act provides various remedies for breach of contract, such as damages, specific performance, and injunctions. Damages are monetary awards designed to compensate the innocent party for loss suffered due to contract breach. Specific performance is an order of the court requiring the defaulting party to fulfill their obligations under the contract. Injunctions are court orders restraining the defaulting party from doing something that would breach the contract. Here's some more information on the different types of damages awarded in contract disputes. Compensatory damages. Compensatory damages are intended to compensate the non-breaching party for any losses or damages suffered due to the breach. The goal is to put the non-breaching party in the position they would have been in if the contract had been performed as agreed. These damages can include direct damages, such as the cost of replacing or repairing damaged goods, or consequential damages, such as lost profits or business opportunities. Punitive damages. Punitive damages are designed to punish the breaching party for their conduct and deter them and others from engaging in similar conduct in the future. These damages are only awarded in cases where the breaching party has acted intentionally or recklessly, and are generally only awarded in cases of egregious conduct. Nominal damages. Nominal damages are awarded when the non-breaching party has suffered a loss, but the loss is minimal and difficult to quantify. These damages are typically a small amount of money, such as 1 rupee, and are awarded more as a symbolic gesture than as compensation for actual damages. It's worth noting that in India, India, the courts have wide discretion when awarding damages in contract disputes, and will consider factors such as the nature and extent of the breach, the losses suffered by the non-breaching party, and the conduct of the parties in determining the appropriate amount of damages to be awarded. Specific performance and injunctions. Specific performance and injunctions are equitable remedies available to the innocent party in the event of a breach of contract. Specific performance is usually granted in cases where damages would not be an adequate remedy, such as in contracts for the sale of unique goods or property. Injunctions are typically granted to prevent the defaulting party from doing something that would result in a breach of contract. Understanding the interpretation and enforcement of a contract is essential to ensuring that the contract is legally binding and enforceable. It is important to be aware of the remedies available in the event of a breach of contract and to take appropriate legal action to enforce the contract. Overall, the Indian legal system provides a range of options for interpreting and enforcing contracts, and parties can choose the most appropriate option based on their needs and circumstances. Key contract law cases in India. Indian contract law has been shaped by several landmark cases that have been decided by the Indian courts over the years. These cases have helped to clarify the principles of contract law and have had a significant impact on the development of contract law in India. Some of the key contract law cases in India include Balfour versus Balfour, 1919. This case established the distinction between domestic agreements and contracts. The court held that agreements between spouses do not give rise to legally binding contracts as they lack the intention to create legal relations. Carlisle versus Carbolic Smoke Ball Company, 1893. This case established the principle of unilateral contracts, where a promise is made by one party in exchange for performance by the other party. The court held that the Carbolic Smoke Ball Company was liable to pay the reward advertised for anyone who contracted influenza after using their product. Satyabrata Ghose versus Mugniram Bangar and Company, 1954. This case established the principle of privity of contract, which means that only parties to a contract can enforce its terms. The court held that the assignee of a contract cannot enforce its terms against the other party. Indian Oil Corporation versus Amritsar Gas Service, 1991. This case established the principle of promissory estoppel, where a promise made without consideration can be enforced if the promisor intended to create legal relations and the promisee acted on the promise. Impact of these cases on contract law in India. The Indian Contract Act, 1872, has been amended several times over the years to reflect changing economic and social conditions. These landmark cases have had a significant impact on the development of contract law in India. They have helped to clarify the principles of contract law and have set important precedents for future cases. Some of the major amendments to the Act are the Specific Relief Act, 1963. This act was introduced to provide for specific relief in certain cases, such as breach of contract, where damages are not an adequate remedy. The act provides for the specific performance of a contract, injunctions, and rectifying instruments. The Indian Contract Amendment Act, 1996. This act was introduced to give effect to the United Nations Convention on Contracts for the International Sale of Goods, CISG. The act amended various sections of the Indian Contract Act, 1872, to make them consistent with the provisions of the CISG. The Indian Contract Amendment Act, 2018. This act was introduced to address certain issues relating to arbitration and conciliation. The act provides for the establishment of an independent body, the Arbitration Council of India, which will be responsible for the promotion of arbitration, conciliation, mediation, and other alternative dispute resolution mechanisms in India. These amendments have had a significant impact on contract law in India. For example, the introduction of the Specific Relief Act of 1963 has made it easier for parties to enforce their rights under a contract, as they can now seek specific performance or injunctive relief in addition to damages. Similarly, the Indian Contract Amendment Act, 1996, has made it easier for parties to engage in international trade by providing a uniform set of rules for the formation and performance of contracts, for the sale of goods. For example, the principle of privity of the contract established in Satyabrata Ghose versus Mugniram Bangar and Company has been applied in several subsequent cases to determine whether third parties can enforce the terms of a contract. Similarly, the principle of promissory estoppel established in Indian Oil Corporation versus Amritsar Gas Service has been applied in several subsequent cases to enforce promises made without consideration. Overall, the amendments to the Indian Contract Act of 1872 have helped to modernize and streamline contract law in India, making it more consistent with international norms and better suited to the needs of a rapidly changing economy. Understanding these key contract law cases is essential to understand the principles of contract law in India and how they have evolved over time. In conclusion, understanding the basics of Indian contract law is essential for anyone who wants to enter into a legally binding agreement in India. In this post, we have covered the key elements of a contract, types of contracts, contract formation, contract interpretation and enforcement, and key contract law cases in India. Here are some of the key takeaways from this post. Contracts are legally binding agreements that require an offer, acceptance, consideration, capacity, and free consent. There are different types of contracts, including express and implied, unilateral and bilateral, executed and executory, and void, voidable, and illegal contracts. A void contract is one that is considered to have never been legally binding and has no legal effect from the outset. In other words, it is completely invalid from the beginning and cannot be enforced by either party. On the other hand, a voidable contract is one that is initially binding, but which can be legally avoided or canceled by one or both parties due to certain circumstances. Contracts can be formed orally, in writing, or electronically. Courts in India interpret contracts based on the intention of the parties, and remedies for breach of contract include damages, specific performance, and injunctions. Landmark cases such as Balfour versus Balfour, Carlo versus Carbolic Smoke Ball Company, Satyavrata Ghose versus Mugniram Bangar and Company, and Indian Oil Corporation versus Amritsar Gas Service have had a significant impact on the development of contract law in India. It is important to keep these key takeaways in mind when entering into any legally binding agreement in India.